You wrote a concurring opinion in the Hobby Lobby case. You wrote about the Religious Freedom Restoration Act this way, quote, "It does perhaps its most important work in protecting unpopular religious beliefs, vindicating the nation's long-standing aspiration to serve as a refuge of religious tolerance," unquote. In other words, Congress enacted RFRA to apply broadly and robustly to ensure that, among other things, the little guy would be protected as much as the big one. Is it fair to say that the court's decision in Hobby Lobby and your concurring opinion upheld this purpose, and in doing so effectively promoted religious tolerance?
Well, I might give you even a couple other examples of RFRA's application that I've been involved in that might shed some light on this. It's the same statute that applies not just to Hobby Lobby, it also applies to Little Sisters of the Poor and protects their religious exercise. And it's also been applied in a case where I appointed counsel because I saw something potentially meritorious there. And our court held it applied to a Muslim prisoner in Oklahoma who was denied a halal meal.
Right.
It's also the same law that protects the rights of a Native American prisoner who was denied access to his prison sweat lodge. It appeared solely in retribution for a crime that he committed, and it was a heinous crime. But it protects him too. And I wrote those decisions as well, Senator, yes. I wrote the Native American prisoner case, and I participated in, and I wrote a concurrence in the Muslim prisoner case.
Well, thank you for doing so. I also want to give you...
As you know, in RFRA, the Religious Freedom Restoration Act, Congress was dissatisfied with the level of protection afforded by the Supreme Court under the First Amendment to religious exercise. The court, in a case called Smith versus Maryland, written by Justice Scalia, said any neutral law of general applicability is fine. That doesn't offend the First Amendment. So laws banning the use of peyote, Native Americans, tough luck, even though it's essential to their religious exercise, for example. All right. This Congress decided that that was insufficient protection for religion. And in a bill sponsored by Senator Hatch, Senator Kennedy, Senator Schumer when he was in the House, wrote a very, very strict law. And it says that any sincerely held religious belief cannot be abridged by the government without a compelling reason, and even then, it has to be narrowly tailored. Strict scrutiny, the highest legal standard known in American law. Okay. I've applied that same law, RFRA and RLUIPA, their companion statutes, to Muslim prisoners in Oklahoma who seek halal meals, to Native Americans who wish to use an existing sweat lodge in Wyoming, and to Little Sisters of the Poor. Hobby Lobby came to court and said, we deserve protections too. We're a small family-held company, small number of people who own it, I mean. They exhibit their religious affiliations openly in their business. They pipe in Christian music. They refuse to sell alcohol or things that hold alcohol. They close on Sundays, though it costs them a lot. And they came to court and said, we're entitled to protection too under that law. It's a tough case. We looked at the law, and it says any person with a sincerely held religious belief is basically protected except for strict scrutiny. So under the religious freedom, Senator, thank you. Interesting, good question. I mean, this is what it's all about. The Religious Freedom Restoration Act protects this exercise of sincerely held religious beliefs and affords them the highest protection known in American law, strict scrutiny. That's a law that this Congress passed because it wasn't satisfied with the degree of protection that the Supreme Court was affording the exercise of religious liberty under the First Amendment, under Smith. This Congress found Smith, written by Justice Scalia, to be insufficiently protective of the right to free exercise. And as you know, the Religious Freedom Restoration Act goes above and beyond the First Amendment in protecting religious liberties. It's a judgment made by this Congress that it's free to amend at any time if it wishes. It can eliminate corporations from coverage. It can eliminate the strict scrutiny that's required, and it can eliminate the act at any time. But, Senator, I gave every aspect of that case very close consideration. That was an en banc decision by our court. I don't think Hobby Lobby speaks to the question of the First Amendment at all. What it speaks to is the question of the Religious Freedom Restoration Act, and what a person is defined under that statute by reference to the Dictionary Act, which is Congress's direction to us when we're dealing with statutes, what words we're supposed to use and what definitions are. And, Senator, if in RFRA, again, if this body wishes to say only natural persons enjoy RFRA rights, that's fine, and I will abide that direction. I'm not here to make policy. I'm here to follow it.
Okay, on to another policy that's pretty important. That's the Chevron case. And in your Gutierrez concurrence, and this is where you wrote the actual opinion and then wrote your own concurring opinion, which I noted is better than writing a dissent to your own opinion. But you wrote a concurrence to your opinion.